Good afternoon, everyone, and welcome to today's webinar. My name is Brittany Adams, and I'm the events coordinator here at Tully Rinckey. And in this webinar, partner Barbara King will provide an overview of why legal separation may be the best option and the different methods for reaching agreement terms.
All right, let's give that another shot. Thank you. I tried to title this aptly for what most people have questions about when it comes to separation versus divorce. And we're going to talk about the distinctions, but we're also going to talk about how to get from here to there, the methods, because the methods help explain what the process is and ways to circumvent the more difficult litigation process. So the three topics listed that we are going to discuss, I'll just launch directly into. Legal separation versus a divorce. In the day of no-fault divorce, why not just sue for divorce? Why do you need a separation agreement? Just briefly to let you know, before 2010, you could not get a divorce in the state of New York unless you could prove adultery, abandonment, cruelty. And so many people who didn't have these grounds or didn't want to go through the very sometimes embarrassing and drawn out and expensive process of proving them would have difficulty in getting a divorce. So New York State went no fault. What that basically means is you simply have to plead in your complaint that the marriage has broken down for at least 6 months. There's been some litigation over what that actually means, but for the most part, it's not questioned. The courts put it through. A sworn statement from the plaintiff that the marriage is broken down is sufficient. Okay, so if it's that easy, why do people do separation agreements? Because the statute, domestic relations law that governs this no-fault divorce, says that the court can't actually dissolve the marriage unless the parties also have a complete, comprehensive settlement or separation agreement signed and duly acknowledged by the parties, resolving all their issues: custody, child support, property division, spousal support, debt division, etc. So if you need the agreement in order to get the no-fault divorce, the thinking is, why don't we try to get the agreement first? Then the actual dissolution of the marriage, the no-fault divorce, is simply paperwork. In these days of post-COVID, and I'm sure we all hope it is post, in these days of post-COVID, the court systems have caught up very, very quickly to the internet, using the internet, and most counties in New York now will allow you to file for a divorce and proceed on a no-fault divorce with a signed agreement in place without ever having to step into court. It is all done on documents signed by the parties, signed by attorneys, and electronically filed. So you bypass the days where you're paying your lawyer to go to court, sit around, wait to see a judge, you wait, then you go back. Cuts down the cost, cuts down the time tremendously. Okay, so I call it the front door versus the back door approach. If my marriage is falling apart, I can sue for a no-fault divorce, even if I don't have an agreement in place. But I now have to go through the court system. I now have to go through litigation, get a judge assigned, see if the judge can help us reach an agreement, see if we can resolve it. And if we can't, then we're going to go to trial. And I have a few slides here we'll get to later that'll help demonstrate what some of this actually shows. Right now, Brittany, just so you know, we're just on the outline slide right now. So you can go through the front door, you can sue for divorce, and then hope that you can settle the case, go through the time and the litigation and the court appearances and paying lawyers, and hope that they can negotiate a deal. And if they can't, hope that the judge can help negotiate a deal. And if the judge can't, then go to trial, call your witnesses, put in your exhibits, testify. A very time-consuming and expensive approach, one that a lot of people have to do. But if we can go through the back door, if we can negotiate an agreement first, get that signed, sealed, and delivered, then we just file everything electronically. You never have to see a judge. So that's really the primary difference between a legal separation and a divorce. So you can always, my thinking is, unless there's some immediate need to rush into court and get immediate relief from a judge, somebody is absconding with marital assets or the children, something really, dramatic. Try to reach an agreement first. If it doesn't work, you can always sue. You can always go through the front door. Okay, time and cost, pros and cons. I've already hit on some of those. One of the most common questions I get when a client asks me to help them negotiate and reach a settlement agreement, a separation agreement, is, how long is this going to take? And my answer is, and has been for over 30 years, is, how long is it going to take you to get to yes? The sooner both parties can agree, give me 48 hours. I can throw an agreement together. I can work on it. I can make the time and I can turn an agreement around. All right, maybe within a week if I'm busy. But it's not the attorney's time normally. It's how long does it take the parties to get to yes? So that's one of the things, and it can be quick. I have some clients that they talk to each other and pretty much know what they want to do. But if things get dragged out, you can always pull the plug and sue for a divorce. So if you've hired a lawyer to help negotiate a separation agreement, 2, 3, 4 months have gone by and basically no progress is being made, the other side is stonewalling, or it's clear you've hit a brick wall, you may want to pull the plug and then look at litigation. And we're going to talk about what some options are on that at the end. Okay, so still under topic 1, legal separation versus divorce, the pros. You control the outcome. That is one of the biggest positives about doing an agreement versus going to court. The parties and the attorneys, especially experienced attorneys that do this regularly, can be much more creative with what they do than a court can do. Simple example, you have a couple who are married and either they have no kids or the kids are grown, and they each have a 401k, there's a house, there's some bank accounts, there's not much to fight over. If they can't agree what to do with these assets, judge's answer is simple. You can't agree what to do with the house? 9 times out of 10, the judge is just going to say, sell the house. Can't agree what to do with the retirement? 9 times out of 10, judge is going to chop these things in half. Judge has a limited menu that he or she can pull from, whereas attorneys and parties can negotiate and be creative. All right, I want to keep the house, but I can't afford to refinance the mortgage right now. You cut each other slack, give each other time, work out details, play with details that a court can't do. So you can be much more creative. You can address detail that a court might overlook. When a case goes to trial, and I've done these trials, they take days and days, and there's stacks of documents and evidence. When a judge gets to writing a decision, they're going to miss something, simply because there's so much in the mix, or there's only so much detail the judge can get down to. And then you get a decision after trial and you realize, hey, the judge never addressed the tax implications of the capital gains on the investment account. How do we pay that? Who's stuck with that? Those kinds of details can all be worked out with attorneys and parties negotiating. I call it the scalpel versus the axe. If a judge has to decide a case, a judge has an axe. Lawyers, parties working together, have the scalpel. They can very carefully carve out and create what the parties really need. Okay, and I'm hoping I'm following these slides properly. We are down to the negatives of the agreement, the cons. It can drag out. When parties are working on reaching an agreement, there is nothing compelling them to resolve their issues. If there's a lawsuit pending, then there's something compelling them. There's a judge acting as a referee saying, hey, if you guys don't have an agreement, come back and see us for a conference. We're going to set deadlines. We're going to set trial dates. When you're negotiating, think of, buying a car. The party that really wants the car is going to pay more for the car. The party selling the car, if there's lots of cars, they're going to want to get rid of it. They're going to drop the price. But the negotiations can drag out, and there's nothing forcing either side to get to yes. So that's the downside of it. And that's where I go back to, if you're not reaching terms, pull the plug. There's no need to keep banging your head against a wall just because it feels good to stop, or pay lawyers just to do something that clearly isn't getting anywhere. One of the other negatives is there is no formal financial disclosure going on. So when parties are working out an agreement, they're trusting that either they have knowledge of what the assets and debts and issues are, or that knowledge is going to be freely shared between the parties. If there's a high level of distrust, if there's a history of a surreptitious activity with monies or assets or whatever, then you may not, be in a position to really be able to negotiate a good agreement, because you never know if somebody is actually hiding things. Now, I almost always have a client who thinks somebody's hiding something. And that may be very well be true. The question is it something that is big enough to litigate over? And sometimes it is. But if, a client says, well, I think my spouse has more money in the health savings account than they're disclosing, that may not be worth fighting over. I think my spouse is hiding an investment account, that could be an issue. There are documents that can be shared during the negotiations that will help reveal if there are some assets that aren't disclosed. But that money that goes in the safe or under the mattress or is squirreled away at somebody's cousin's house, it's going to be very hard to find. And if there's a lack of trust, that's a downside. Also, if there's an imbalance of bargaining powers, somebody is completely out of the loop on any of the marital finances, that could be an issue. If there has been domestic violence and that creates a significant imbalance in the parties, certainly that's going to be able to affect the ability to get to an agreement. What are some of the life effects of just doing a separation agreement instead of going directly for a divorce? An agreement can take into consideration things that a court can't quantify. The adjustment time that the children need to ease into the breakup of their parents, depending on the age of the kids. That can be something that really has to be taken into consideration. You have a child suffering from anxiety. Just accepting that mom and dad are separating is a step before mom and dad are divorcing, and sometimes that will guide the decisions you want to make. Life effects, time and cost. Again, how much money do you have, and do you want to put it at litigation or trying to reach an agreement, and how much time do you have? Is there some reason why you need a divorce sooner rather than later? And if the negotiations aren't working, maybe you have to proceed into court. As I said before, maybe there is a hemorrhaging of marital assets that has to be stopped, or somebody's moved out of the home and isn't providing support for the spouse or the children. You may need court intervention, and negotiating isn't going to work. Practical effects of an agreement. It does sometimes help preserve the future of the relationship, which may not be a concern if someone says, I'm divorcing, obviously I don't care. But if you have children together, I always advise clients, think about the fact that someday you're going to be sitting at a graduation together, or somebody's going to be pulling their hair out, trying to figure out where to put people at the wedding reception because mom doesn't talk to dad. And that can be very difficult for children down the road, even as adults. So take into consideration that if you are going to be connected to each other for the near future, and if this is going to affect a third party, you want to try and preserve that relationship as much as possible. Practical effect of an agreement also is if you sign a separation agreement, but you don't divorce right away, and you don't have to. I had a client who stayed legally separated for 20 years. It does affect your tax filing. In New York State, a married couple can file married joint or married separate. They cannot file single. I will defer the pros and cons of that to the accountants. I'm not an accountant, but it is in general usually a better tax bracket to file married joint. Single is second best, but married separate is usually not the best to file in. So until the marriage is dissolved, You'll either have to work out whether you're going to continue to file joint taxes, which most couples don't do, or you're going to have to file married separate, and that could impact your tax obligation. One of the good things is you can preserve joint health insurance. So if your spouse is covered under your health insurance, as long as you're still legally married, they can stay under your policy. The loss of the family coverage for the spouse does not occur until there's been a judgment of divorce entered. At that point, what we call the COBRA, the federal statute regarding coverage of medical insurance, will kick in, and the spouse can pick up coverage through the other spouse's employment, but they have to pay the premiums, and they tend to be a bit pricey depending on the coverage plan. But I do have many clients who have signed separation agreements and deferred the dissolution of the marriage because one of the parties was undergoing some medical treatment. And I had a client who's undergoing treatment for breast cancer. So they didn't divorce for about 6 years till she got through all her treatment and reconstructive surgery. So that's something that does benefit. Also, the one final thing before we go to the process discussion to keep in mind about a separation agreement, whether that's what you want or whether you want to divorce sooner, is if you are dividing tax deferred accounts, what I have listed there as ERISA, E-R-I-S-A, that's just the acronym for the federal statute. If you're dividing a pension, a 401k, an IRA, most of these, I'd say more than 90% of these accounts, they can be divided at any time before you divorce. The problem is that if you invade these accounts and try to divide them, let's say a 401k, 403b, if you invade an IRA and try to divide it before you're divorced, you're going to get hit with penalties and taxes. Definitely taxes. Penalties only if you're under 59 and a half. So if I'm divorcing and I have $100,000 in a 401k and I've got to give half to my spouse, we're not going to want to make that transfer until after we're divorced and we get a complementary order along with the judgment of divorce called a qualified domestic relations order. People call it a quadro. If we divorce and we get that order, then we can split that IRA and nobody gets hit with penalties for splitting it. And my spouse will only pay the taxes if he opts to take the money out. But if we try to do that before we're divorced and before we have a qualifying order splitting that account, 20% right off the top, mandatory withholding of taxes. And if you're under 59 and a half, another 10% penalty. So almost a third of the money's lost right off the top. I'm pointing this out because a lot of people have money in pensions and these tax deferred accounts. And if you need to get your hands on that money sooner rather than later, then you're going to either want to defer doing a separation agreement, go immediately for a divorce, or if you do enter a separation agreement, immediately get it turned into a divorce. Get your court order to divide those accounts. So just a word of warning out there. Okay. I want to move on to process because this goes to, and that should be the next slide. Yes, good, thank you. This talks about how do we get from here to there. Bottom line is what I want you to be able to walk away from predominantly is understanding that separation agreements are a wonderful way to resolve your marital issues and avoid expensive and drawn out divorce actions, if you can do them. And even after you sign an agreement, there may be reasons you don't want to then dissolve the marriage right away. Health insurance, children's issues. There may be a reason you do want to dissolve it right away. I need to get my half of that IRA. Whatever your decision is, how you can get to this agreement is not a cookie cutter way of going. There are options for doing this, for getting from here to there. And then the last thing we're going to look at is what does litigation look like compared to reaching an agreement? Because by comparing and contrasting the two, it makes it more clear. Okay. Option one, I think we have a slide for that with a little picture. There you go. Okay. And I got very good at drawing these little graphs upside down when I would sit across the table from a client describing the processes. So I've turned them into slides now. Option number one is the one-on-one communication. This is rare, but I've seen it happen and work many times. This is a process where usually one or both of the spouses consults with an attorney, or maybe they haven't even consulted with an attorney. They're savvy enough, they sat down, they're amicable enough, and they're able to actually talk to each other and say, look, we know the marriage is going to end. We can do it the easy way or the hard way. As I say, you can save for my retirement or yours, right? You can either get the lawyers into retirement or yourselves, right? Keep the money between yourselves. If the two of you have enough equal bargaining power, equal knowledge and trust in what the assets are and in each other, and a desire to try and just get as much of the terms and work done as you can before you hand it over to attorneys, and you can talk, do that. Again, assuming there's no domestic violence, there's no intimidation, do that. I encourage it. It's your stuff. It's not our stuff. In the end, we go on to the next case. This is your life, your future. You want to talk to a lawyer before you sit down and talk to your spouse, that's fine, whichever way you want to go about it, but you should know what you're talking about before you sit down. I mean, obviously, as an attorney, I'm going to say you should talk to a lawyer before you talk to your spouse, because you don't want to give up the ship, as they say. But some people are able to sit down over a pot of coffee at Dunkin' Donuts or Panera's and actually come to a general outline of what they want. And if they can do that, one party can hire an attorney to put that together into a comprehensive agreement. The lawyer is not just monkey working what you gave them. The lawyer is plugging all the holes, things that we know you need in that agreement that you probably don't know, things that we know the court's going to want to see when you go for a divorce, things we know that you're going to have to think about the effect of in 2 years, 5 years, 10 years, and 20 years, helping you think around every corner and know what needs to go into the agreement. But essentially, the lawyer's taking the direction from the clients. There's no formal exchange of financial discovery going on. This is a very trusting process. I would say 15%, maybe on a good day, 20% of my clients are actually in a position to do this and feel very comfortable with this. The assets are very well defined. There's no businesses, no hidden cash, nothing hinky going on. So that one-on-one communication, and then the lawyer is brought in to prepare the agreement. The other spouse can have the agreement reviewed by an attorney if they want to. That attorney may want to have some input into the agreement, or the other spouse may just say, it says what I want it to say. I like it. I'm going to sign it. As long as it addresses all of the issues, this will be can be turned into an appropriate legal separation agreement. These agreements have to be properly acknowledged. I'll get into that a little bit more, but this is rare. Usually I see it in short-term marriages, marriages with few assets, or marriages where there is full financial sharing, asset awareness. Consultation with counsel and guidance through the process with counsel is recommended. Again, you don't want to have your first sit down with your spouse and say, oh, okay, you get half my pension. And it turns out that 50% of that pension was earned before you even married your spouse. And they're really not entitled to 50%. They're only entitled to half of the half that was earned during the marriage. So someone wants to be generous, a lawyer's not going to stop them, but the lawyer is going to tell them what they have to do and what they don't have to do. So get that advice first. Option 2 is the next slide. The mediation model. I do not do mediation. I've done some mediation training, but I don't mediate. I don't do it because I can't really shift from advocating to mediating in my mind. I'm one or the other. And this is why there are limited numbers of people who do divorce mediation, if you're going to go through this model, and we'll run through it ourselves here, but my recommendation is to research who the mediator is, what is their training, are they versed specifically in divorce, even though you're going for a legal separation, they'll call it divorce mediation. How experienced are they? There are not a lot of really good divorce mediators out there right now. There are a handful, so be careful and research it. The mediation process, I draw it as a triangle because at the top is the mediator and the lower corners are the parties, spouse one and spouse two. What I didn't draw on there, but I will describe for you, is along each side of that triangle, each spouse should be consulting with an attorney through the process. The attorneys do not go to the mediation with the parties. The attorneys, one may have one may not, or they both may have attorneys, but the recommendation is if you are going to use this model, that you have an attorney consulting with you in between the mediation sessions to advise you and prepare you for each next level. Okay, so what is this? A mediator is not going to give you legal advice. They're not supposed to. If they do, they're not doing their job. They're not allowed to give you legal advice. A good mediator will signal to the parties when they think the parties need to stop, break, and consult with counsel. Maybe he or she sees that they're heading toward trying to agree to something that the mediator knows is problematic. The mediator can't tell either party what's going on, but they can say, I want you to consult with attorneys on this issue, and then we'll come back and discuss it at the next session. So that's the most they'll be able to do. The mediator has no stake in the game. If spouse one ends up with 90% of the assets and spouse two ends up with 10%, and they do it with full disclosure, and that's what they want to do, the mediator doesn't care. The mediator's only job is to get both sides to yes. What that yes looks like is really up to the parties to be talking to their lawyers and making sure they know what they're doing. If my client wants to give up 90% of the assets, I'm not going to stop. I'm going to warn them. I'm going to make sure I have it in writing and they know that they're doing something that they don't have to do and that I've advised them otherwise. But it's not my job to stop them, nor is it the mediators. So understand that going to mediation does not offer any legal protection to what you're doing. Mediator, I think we covered, let's make sure they're trained. Most of them now, again, post-COVID, can do it virtual, which makes it much easier. They do it over Zoom. Most of them will not and should not do it if there is some ongoing domestic violence. Even though you're not sitting in a room together, it may trigger an imbalance of bargaining powers. You know, now that it can be done virtually, they are taking in more clients where there's a domestic violence history. But if there's a clear bullying going on or imbalance of bargaining powers, they're going to shy away from it. Most mediators will do a first introductory session with the parties to explain the process, how it works, how they charge, what happens at the end. And then if both parties after the introductory session want to proceed, then they will usually sign a retainer and move forward. And they will schedule topic by topic. One of the mediators that I use predominantly will address the children first. And I like that typically because your house can burn down or you can sell it and buy a new house. Your 401k can tank as they have in the past. You can't replace the kids. So if you cannot resolve the children first, chances are you're going to be wasting your time getting to all the other topics. And that's not an absolute rule, but we like to try and tackle that first because that's usually where parties are, you know, wanting to preserve the relationship and preserve the health of their kids and can cooperate more. But that's just not everybody does that. It's still on a voluntary basis. There is no formal exchange of financial data. The mediator will require that each party provide a list of assets and debts and estimated values. If they don't know the value of a particular asset, the mediator can direct them to an appraiser, say to find out what the house is worth if one of them wants to keep it. but the mediator's not guaranteeing that these numbers are accurate or that there is full disclosure going on. So again, there's a level of trust required. Because the parties, one or both, are or should be consulting with their attorneys in between sessions, the attorneys can help the clients gather the documents they need, dig for the information they need, review tax returns, get information that the parties need. So when they go back to the next session, they know to be prepared. For example, the mediator may say, all right, when we meet in 2 weeks, we're going to talk about the retirement accounts. Well, go talk to your lawyers, because now you need to understand what are defined benefits plans, what are defined contribution plans, what are the penalties and tax implications, what is a shared pension, what is a separate pension, what's a DRO, what's a QDRO, what's a survivor annuity, what's a joint, what's a pre-retirement death benefit. You need to know these things going into the mediation, and the attorney can equip you for that, so that you don't walk away saying, I get half my spouse's pension, but I forgot to get a survivor annuity. And if my spouse gets hit by a bus a week after we're divorced, I'm out all that money. So things like that, the guidance. So it can feel a little bit insecure saying I'm going in and talking myself, but if you have that coaching going on, it is a very successful model. And I would say 80% of my clients that go to mediation, if they go to a good mediator, 80% come out with an agreement. And that's tremendous. If you think of cost sharing, if the two of you retain a mediator and you pay the mediator's hourly rate, hypothetically, let's say it's $300 an hour, you're each paying $150. If your lawyers are doing all this talking for you, you are each paying your lawyers, say hypothetically, $300 an hour. You're multiplying the cost. So it's a very effective model. And the reason I point clients to it, if I believe it is in their best interest, and for a lot of them it is, I explain that as a lawyer, I lose money if you mediate. I make money if you litigate. But if I'm pointing you in this direction, it's something that I think you should consider and try, because it could help. Okay, let's go on, trying to track the time. A few more things under this mediation I want to mention. Some mediators go beyond just mediating. What do I mean? Let's assume that you get through this whole process. You've done half a dozen sessions. Barb, next week we're splitting the furniture up. I don't really need to consult with you about that. You know, we're just going to go in and come up with a list and split the furniture. So you don't necessarily need your lawyer for every advice for every session. But some mediator, generally what a mediator does when they're done, assuming the parties have successfully addressed everything and completed the process, the mediator will draw up what's called a memorandum of understanding. It's what I call a Reader's Digest version of what you've agreed to. It is not a comprehensive separation agreement. It is simply, half a dozen or 8 pages spelling out, here's what we're doing with the house, the kids, the cars, the bank accounts, the debt, etc. The lawyer then uses that as the blueprint to prepare a separation agreement. The other side, again, if they have a lawyer, will also get the memorandum, who will review it. One lawyer will draft, one lawyer will review or edit. Hopefully there's no outstanding issues. Hopefully things stay, comprehensive, and somebody doesn't throw I changed my mind into the whole thing. And this is why I say 80% of them are successful. Once the final agreement's been drawn up, the parties sign it, they're legally separated. You can hit lotto and all that money's yours. You can go bankrupt and all that debt is yours. You can start a new business. You can date. You just can't remarry yet. You're not divorced. So before I go off mediators, this is what most do. They draft the memorandum of understanding. There are some mediators out there who will actually draft the agreement itself. I'm not a fan of that. Not because I'm, neurotic and I'm a control freak and I like to draft things. It's because the drafting of the document is in and of itself advocacy. There are so many details and protective mechanisms and things that need to go into that agreement to protect the client that in my opinion, it's okay, mediators are allowed to do it. It's not unethical, but in my opinion, it's advocacy and it should be done by one of the attorneys and reviewed and edited by the other. It should not be drafted by the mediator. Once the mediator drafts the agreement, the parties are still free to have lawyers look at them. But then any edits have to go back through the mediator, and you may be recycling through the system again and renegotiating things. So it could end up being a bit more costly. There are some mediators, but very few. There are some who will actually go the third step, not just mediate, not just draft the agreement, but will actually process the divorce. Again, that is not unethical. New York State Bar has said that's okay. But again, that goes to, in my mind, that goes beyond mediating. It goes to advocacy because the mediator has to technically represent one of the parties in the divorce. And even though it's no fault, and even though it's just going to sail through the system now, I still have an issue with that being done, but it's done. And if that's the road you opt to go through, that's perfectly fine. I do, however, suggest you still get some advice along the way. Okay, option 3, if we can go to that slide. Okay, this is what I call the telephone approach. Spouse 1 calls their lawyer and says, this is what I want, who then calls lawyer 2, who has a conversation, and then calls spouse 2. And spouse 2 says, all right, let me think about it, gets back to lawyer 2, who then gets back to lawyer 1, who then gets back to spouse 1. So as you can see, the expense that you pay by the hour to each attorney is going to go up significantly. However, this is at least 50 to 60% of the negotiating that I engage in, and most divorce or separation, counsel engages in, because a marriage is a very sensitive, close relationship, and not every couple can have these conversations. There's a reason the marriage is falling apart. There are differences, and these are sensitive things. Some people are not good at advocating for themselves, so they need to go through the attorneys. I advise my clients, if I say, look, we're going to ask for this, or you need that, or you're entitled to this, and the client says, yeah, but I'm just uncomfortable. I want it, but I'm uncomfortable asking for it. I tell them, make me the bad guy. I'm the lawyer. I'm the one that's telling you this is what you need and want. You're agreeing with me. Let me take the load for making the demand, because not everybody's comfortable bargaining for themselves, and that's understandable. And also in this model, again, while there is no mandatory disclosure, there is no depositions, there's no subpoenas, there's no formal discovery demands. In this process, what we typically do is we have the parties exchange what are called statements of net worth, which are financial affidavits signed under oath by the parties each, disclosing all of their assets and debts, so that at the very least, we know that the parties are in a position where if they knowingly failed to disclose or misrepresented an asset or a debt or a value or left something off, we have some recourse because we have a notarized, signed, and sworn to financial affidavit between them. Lawyers also know where to dig for financial data, and lawyers can also pick the phone up and call each other and say, hey, you know what? I want to see that 401k statement. My client thinks there was more money in it. I want to see the last 3 years. Was money taken out? We want to look at tax returns. Can we tell if something's been invested in or liquidated? So we know where to look for things to help uncover as much as possible without going through the formal litigation process. So there's a benefit to this, although there's an additional cost to this. You are still in control of the process. The attorneys are doing the negotiating for you, but you are still in control of the process. You're still telling the lawyer, here's my priorities, here's what I really want. I have clients, I ask them usually at the beginning, give me your top 3 priorities. What are your non-negotiables in order of priority? So that I know if my client really, really wants to keep the house, maybe my client's not so concerned about a pension that their spouse may get 20 years from now. I can't get my piece of the pension for 20 years, and my spouse has only been working for the state for 5 years, so I'm going to get a tiny sliver of a pension. I got to wait 20 years for it. The house is more important to me. all right, so I know what I can negotiate for the client to reach their goals. And those goals may change as the case develops, but you're still in control. And the same theory runs as with reaching an agreement through any other mechanism. And that is, if my client wants to give more than they have to give, or wants to take less than they're entitled to, that's okay. My job is to make sure we know what the assets are, what their rights, what they're entitled to. And if they're going to do something different, they do it knowingly. So this process distances the parties from what I call the ask, what they're asking for. Make the attorney the bad guy. That's fine. You know, gee, I didn't know I was entitled to it, but my lawyer says it's really important for my future, you know, if the parties still have to interact. But again, as with any of the other processes, if this drags out, it's not going anywhere, stop banging your head against a wall. You can always pull the plug and litigate. Let's look at the last slide, which is the litigation slide. And I put this up simply to allow you to have something to compare the option 1, 2, and 3 with. This is what I call the litigation train tracks. And I think because there's 2 lines there, it's like a train track. Let's say you either choose not to try and negotiate an agreement first. Again, there's some imminent issue. You need to get in front of a court sooner rather than later. Or you did try one or all of those options and none of them worked. You can stay married. You know, when clients ask me what are their options, they think I'm crazy when I mention that, but that really options are about what's the whole world offer you. Generally, you know, I'd say 98% of my clients don't do that. Sometimes the issue that's holding up settlement can be resolved in family court. They agree on everything else, but they can't agree on custody. Maybe what we do is we send the parties to family court to resolve the custody or the child support issue. And once we resolve it in family court, now we can go back to the negotiating table and reach a settlement agreement. If not, we can go to litigation. What is that? In a nutshell, one party files an action for divorce. It is for, it's what we call no fault. The marriage has fallen apart for the last 6 months and somebody wants out. That gets filed, it gets served on the other party. The other party usually comes forward with an attorney. The attorneys start talking. If the attorneys see that they're not going to get anywhere very quickly, or maybe they already know that, they request a judge to be assigned, judicial assignment. It's done through the computer, pay a fee, and it's done. Then a judge gets assigned. And again, things are a lot quicker now because we don't have to wait for the mail. A judge gets assigned to the case. A judge will schedule a preliminary conference. The parties will produce their financial statements, share them with each other's attorneys, provide one to the court, appear in front of the judge. The judge is going to use this conference to say, what's this case about? How long have you been married? Are there kids? What are the issues? What are we fighting over? Do we need appraisals? Do we need experts? And the judge will set a scheduling order. It's almost like being a referee. And we'll say in 30 days, I want tax returns exchanged. In 45 days, all your discovery demands are out. In 60 days, I want them all answered. Come back to me in a month for a status conference. Is everybody behaving? Are documents being exchanged? Are you talking settlement? Are you making progress? What's the hiccup? Still can't settle the case? Come back in 30 days, 45, 60 days for a compliance conference. Do we need an attorney appointed for the children because you're fighting over custody? Do we need the court to order a neutral appraisal because you can't agree on who's going to appraise the business? Do we need legal fees? Do we need temporary support? Are motions made? Okay, can we settle the case? If we can't, come back. We're going to have a pretrial conference. Who are your witnesses? How many exhibits do you have? How many days of trial do you need? Can't settle the case? Come back for trial. The end station, every train has an end station. The end station, if the court can't help you derail this with that bottom line there, settlement talks, if the court can't help you or the attorneys can't help you derail this off the litigation track, the end station is trial. And that's where you put your lives into the hands of an educated and hopefully very experienced and knowledgeable judge who's going to do the best job they can, but you're one of 100 cases on their docket. they're going to move on to the next one. Whatever they decide, you're going to be stuck with. So always circles back to, if you can stay in control of the process at all, that's what you want to do. And if you can do it through one of these models, that's the way you want to try to approach it. It may not be in your best interest to sue. If you can't reach an agreement, I have a client right now, she holds title to the house. She has the retirement money. She's collecting her pension. She has a house she inherited in Florida, and they have no kids. They're not working anymore. They're retired, and she wants a separation agreement, and the spouse is dragging his feet. And she said, I want to sue. And I told her, I'm not sure suing's in your best interest, because the sooner you sue, the sooner you're going to have to buy him out of the house. Actually, yeah, right. The marital house. She doesn't want it. He wants it. The sooner you're going to have to give up half your pension. The sooner you're going to have to be giving him more of your investment, because most of the money is in your name. The sooner you're going to have to give things up. So in reality, she said, well, I don't want to be married, but I also don't want to give up half my pension and half my investments. So I'll let him stay in the house, and I'll go live in my inherited house in Florida. And sooner or later, he may come around and want to settle. But if he doesn't, unless and until she really wants to be divorced so she can remarry, she's probably going to sit on the case, because it's not in her best interest to move forward right now. So sometimes holding out is the way to go. Sometimes addressing issues through family court. Look, I don't want to litigate, and I really don't care if I'm divorced, but I really need spousal support. My spouse left, and I need money to support the home. Maybe we'll just go to family court and get an order of spousal support. So there are other options to litigation, and all of these should be explored. But ultimately, if the marriage is over, negotiating an agreement, if at all possible, is really the best way to go. So we've got about 12 minutes left, and perhaps if there were some questions, we can open it up. My hope is I've answered a lot of them, but I'm sure there are some.
We did have 2 pre-submitted questions. The first one is, how can having an inherited property really affect the separation process?
Very good question. If New York state law says that everything you acquire during the marriage, so think of it like a timeline, date of marriage to date of divorce or separation, anything acquired on that timeline is marital property, regardless of whose name it's in. However, there are 3 exceptions: inheritance, personal injury lawsuit settlements, or gifts from third parties. Uncle Joe gifts you a BMW. Now, where people get in trouble is when they inherit something during the marriage and they put their spouse's name on it. Or so if this person inherited a house and then they put it in joint name, right? Now they have gifted half of that inheritance to their spouse. And while there are techniques for pulling that back, it's not that easy, and it can be more time consuming and expensive. Or you inherit a investment account and you deposit that money into a joint bank account, or you deposit it into your personal bank account, but then you start dumping your salary into it or other money into it. You commingle the asset to a point where it is transmuted from what you could have kept separate to what is now marital. So how does that play into a separation agreement? That's part of the assets that have to be identified, and it's got to be ferreted out. Is it marital property? Is it separate property? Has that separate property been compromised by being commingled? And if so, how do we negotiate pulling that back out of the pie, so to speak, if possible?
All right, and it looks like we have one more pre-submitted question. What will happen if a spouse owns a business in another state and then tries to sell it before officially being separated?
Okay. Well, whether the business is in another state or in this state really doesn't matter. Again, if the business was acquired during the marriage, if it is a marital asset, then it doesn't matter where it's located. It will have to be considered in the equitable distribution. Now, the other piece of this question, though, that was raised is a very good point. And that is, if we haven't started a lawsuit for divorce, we're just negotiating, or maybe I'm thinking about it, my spouse doesn't even know it. There is nothing stopping either party from transferring assets. Right now, I can transfer any asset in my name that I want to. And nobody's going to do anything about it because I'm married and my spouse can't stop me. So until a lawsuit is commenced, and this is why I said some people may need to start litigation right away because something's going on, like a hemorrhaging of marital assets, something hinky's going on. That's the only thing that's going to put a stopgap on protecting those assets from being transferred, liquidated, wasted, dissipated, or whatever. So this process of negotiating a separation agreement, if the parties are working in good faith, the hope is no one's out hiding assets or transferring assets. But if there's a suspicion of that, then you might want to commence a divorce action right away, because by doing that, automatic restraining orders go into effect by law that say neither party can transfer, liquidate any assets without either the permission of the other party in writing or just in the ordinary course of business. I got to pay my bills every month, so obviously I'm going to access my bank account. So where there's a concern about an asset that may be transferred, you definitely want to consider the possible need to file an action to put those restraining orders in place. The reality is that unless somebody is dealing predominantly in cash, most of the stuff can be traced. So, if I find out my spouse is transferring something, but I don't sue for 6 months or even a year later, there's a look back. They can look back, typically even in discovery, we look back 3 to 5 years. So most of these things can be traced. And if, so let's say my spouse gave our Vermont vacation home that we acquired during the marriage, it was just in his name and he gave it to his cousin, there's a record of that. And if he gave it to his cousin for 20 grand and it's worth 350 grand, obviously he's going to be responsible for the fair value of the assets. But now you're getting into litigation and lawyers and everything.